Ready? Start. It is true that the plaintiff had averred in the plaint that the defendant was closely related to her and she had entrusted the management of the scheduled land to him, and on his request she had leased the suit land to him in the year 1971, and he had paid the rent by way of share stop. But the plaintiff further specifically alleged that the defendant had denied her title and claimed title in himself, and he had also denied the relationship of landlord and tenant, and therefore the defendant was a trespasser and she was entitled to sue for passion to evict the trespasser. Stop. The averments relating to defendant earlier being the tenant furnish the factual background leading to the cause of action for the suit stop. The averments in the plaint should be read as a whole stop. If so done, it is clear that plaintiff claims that defendant is a trespasser in the suit land stop. Significantly, the defendant in his written statement did not allege that he was the cultivating tenant of the suit land stop. Next para. On the other hand, he denied the title of plaintiff and asserted ownership and the title in himself by adverse possession, alleging that he was in occupation of the suit property since 1957 in his own right. Stop. He categorically stated that plaintiff was never his landlord. Stop. Neither plaintiff nor defendant claimed or admitted that there was relationship of landlord and agricultural tenant. Stop. To repeat, plaintiff's case was that the defendant was a trespasser. Stop. Consequently, tenancy was not an issue in the suit. Stop. Section 13 requires an application to be made to the special officer under the Act only when a landlord wants to terminate the tenancy and evict his cultivating tenant and not otherwise. Stop. When plaintiff's case is that the defendant is a trespasser and the case of defendant is that he was the owner and he was never a tenant of the suit land either under plaintiff or anyone else, the suit was not for eviction of an agricultural tenant and therefore section 13 of the Act was not attracted. Stop. Next para. The appellant defendant contended that as he had denied the title of the plaintiff, the case would squarely fall under section 13 subsection E of the Act. Stop. He submitted that section 13 subsection E contemplated termination of tenancy and filing of an eviction petition against the cultivating tenant if the cultivating tenant willfully denies the landlord's title to the land, and therefore the remedy of the landlord was to terminate the tenancy and seek eviction of the cultivating tenant by making an application under section 13 subsection E of the Act, and a civil suit was not maintainable. Stop. Termination of tenancy and eviction petition under section 13 subsection E are contemplated only where the defendant is the cultivating tenant and the defendant willfully denies the landlord's title to the land. Stop. In this case, the defendant denied that he was the cultivating tenant of the suit land and plaintiff claimed that defendant was a trespasser. Stop. Hence, the first requirement for application of section 13 subsection C was not satisfied. Stop. Next para. It is true that the plaintiff had averred in the plaint that the defendant was closely related to her and she had entrusted the management of the scheduled land to him, and on his request she had leased the suit land to him in the year 1971 and he had paid the rent by way of share. Stop. Guys, there is one request. Please always try to repeat the matter so that your accuracy will maintain. And there is one more request. Please subscribe my channel for next audio. Thank you very much.